Díomh agus go míle agus Laura agus dar chéile asach an pí ceol áling sin. My name is Órla O'Donnell. I'm the legal affairs correspondent for RTE News. I'm neither a journalist or neither a historian nor a lawyer, a mere journalist. But one of the perks of my job is that I get to drop into all the most interesting cases, and I've been doing this job for 16 years now, so I've seen quite a lot of interesting constitutional cases in my day. It's one of the areas I've always been fascinated by, constitutional law and seeing the constitutional cases in action. And when a case is ongoing, we're really privileged to see that oft-repeated line about a constitution being a living, breathing document in full effect. And I'm thinking maybe most recently of the 2018 case about the rights of the unborn, where the arguments on both sides and the interjections from the bench were absolutely fascinating. And when the judgment is handed down, then it's a really enjoyable challenge for someone like me and some of my colleagues here to have to explain in simple language the real-life effect on our laws and on our lives, and to demonstrate simply why the court has made the decision it has made, with reference, of course, to the Constitution. And it's fitting that our last session today features the reflections of those who make those decisions and those who are charged with giving life to and interpreting and protecting the 1937 Constitution, and who are perhaps uniquely placed to be able to reflect on that Constitution and on the Free State Constitution of 1922. Their reflections will feature why we should remember the 1922 Constitution, even though it was only in effect for 15 years, what those who drafted the 1937 document learned from 1922, and how the courts at the time discussed and dealt with the 1922 Constitution. Firstly, we're going to hear a recorded contribution from the Chief Justice, Mr. Justice Donal O'Donnell, who unfortunately can't be here in person, but he himself will explain to you why he can't be here and the relevance of that to the events that you've been discussing and commemorating today.
Good afternoon. I'm very sorry I cannot be with you in person at this event to commemorate and discuss the 1922 Free State Constitution. Unfortunately, the event comes at a very busy time for me. We have just returned from a bilateral exchange with the Bundesverfassungsgericht in Karlsruhe, and I'm currently attending a conference celebrating 70 years of the European Court of Justice in Luxembourg. It does strike me, however, that there is a clear connection between these events and the drafting and enactment of the Irish Free State Constitution 100 years ago. In some ways, perhaps I would not be here in Luxembourg, as it were, if that diverse group of men had not gathered in this room in the Shelburne Hotel and devoted themselves to the task of producing a constitution. First, I would like to sincerely congratulate both Laura Cahalan and Donal Coffey on the organisation of this event. It is a really impressive lineup of speakers and some fascinating topics. It is right, perhaps, to start, however, with the question of why it is important to commemorate a constitution that, after all, existed for only 15 years and was acknowledged to have flaws and to have carried within it the seeds of its own destruction. The 1920s were undoubtedly an era of enthusiastic constitutionalism, but subsequent decades were very turbulent waters for those constitutional vessels constructed in the immediate aftermath of the First World War. And the 1922 Constitution, in my view, was no exception in this regard. First, it was weighed down from the outset by the inclusion of provisions from the treaty, such as the Oath of Allegiance, all of which were almost universally unpopular in Ireland. Second, it was drafted by theorists, but put in the hands of legislators, administrators, and to a large extent a legal community, which did not always appreciate its possibilities, or indeed its values. Third, the drafters, although themselves people of considerable substance, did not necessarily go on to take a prominent role in the public affairs of the state, such as to capture the imagination of subsequent generations in the way, for example, that the drafters of the US Federal Constitution did. And fourthly, and in any event, as we know, the Constitution carried, as it were, a hairline fracture below the waterline in the provisions of Article 50, permitting its amendment by ordinary legislation, and which would, in due course, sink the Constitution. And so, after 15 years, it was, having been eviscerated by a process of amendment permitted by Article 50, revoked and replaced by Bunreacht na hÉireann, which, in a significantly amended form, remains our basic law. So why consider the 1922 Constitution? In my view, the continuing value of study of the 1922 Constitution, and indeed the continuing value of the Constitution itself, lies in part in exactly what occurred in 1937, when a new Constitution was drafted by an administration comprised of those who had opposed the treaty settlement and indeed the Constitution that followed it. And while significant changes were made in the 1937 Constitution, innovations introduced, what was striking was that the essential structure established in 1922 remained. And that was, I think, because, leaving aside the features of the treaty which were required to be contained in the Constitution, and some experimental innovations which did not take root, the essential structure of the 1922 Constitution was at its heart a very modern document. Interestingly, I think this may have been partly because of the extensive study the committee made of the existing constitutions of the world, and in particular those emerging in the aftermath of the First World War. This infusion of modern, secular and democratic optimism had a significant influence, I think, especially when you consider the visible piety of members of the committee such as Hugh Kennedy and Alfred O'Reilly. And the 1922 Constitution established something that only really became the norm in the period following the Second World War. That is, that it established a state based on a separation of powers in which the institutions of state were created and defined by law and limited by a constitution providing for fundamental rights, and providing, furthermore, that those limitations on rights could and would be enforced by actions in the court, and perhaps, as importantly, that the decision of those courts would be and have been complied with by the other branches of government. And so I would like to take this opportunity to touch very briefly on this last feature of the Constitution, that is, the provision for judicial review contained in Article 66 of the Irish Free State Constitution and now contained in Article 34.3.2 of the 1937 Constitution. I remember being fascinated by the 1922 Constitution when I first encountered it. I think part of that was the fact that it was clearly the product of idealism, both international and national, and that it was, in that context, perhaps the last opportunity to avoid both the divisions that led to the Civil War, and which has scarred Irish affairs in the succeeding 100 years, but also perhaps one of the last points at which the business was being visibly conducted and approached almost on an all-Ireland basis. Partition had not yet really taken root, and accordingly, at least 3 of the participants in the drafting of the Constitution had strong connections with what is now Northern Ireland, and the drafting of the 1922 Constitution and the discussions that went on are a glimpse, perhaps, of a different Ireland, without partition and without civil war. The provisions for judicial review contained in Article 66 were described later by Professor John Kelly as potentially crucial, and they are obviously central to those aspects of the 1922 and 1937 Constitution which involve the courts and which involve so much study and debate among lawyers. When I first encountered the Constitution, it was said generally that the inspiration for Article 66 came from the US. Thus, for example, Hugo Flaherty in his book of essays, Justice, Liberty and the Courts, could confidently say of our Constitution that judicial review, quote, came to our present Constitution via the Constitution of the Irish Free State from the Constitution of the United States of America. It was said generally by the standard texts and discussions of the drafting of the Constitution that the inspiration of Article 66 was either or both Kevin O'Shiel, one of the Northerners I mentioned, who, it was said, had written a book about the US Constitution, The Making of the Republic, published in 1920, or that it could be traced, or that it might also be traced to the influence of C.J. France, an American member of the committee who had met James Douglas while being active in the work of the Irish White Cross, and thus Atkinson and Fallon, in their interesting series of articles in Era Ireland in 1970, could say he, that's C.J. France, was a useful addition because he possessed a familiarity with the structural advantages and disadvantages of the American Constitution. Taking each of these in turn, I remember acquiring a copy of The Making of the Republic and opening it with some excitement, and then discovering that it does not really contain any account of the American Constitution or American constitutional law, still less judicial review. Instead, it was an account of the American Revolution of 1776, rather than the Federal Constitution of 13 years later. Furthermore, we know that Kevin O'Shiel did not attend many of the meetings of the committee and did not consider himself to be in a position to sign any of the drafts of the Constitution. While he is a very significant and interesting figure and left a fascinating account of his life, particularly in the early part of the 20th century, nothing in his background or subsequent career suggests to me he was particularly interested in US constitutional law, or indeed the theory of judicial review. Now, C.J. France from Seattle was another intriguing member of the committee. He was initially a much valued member of the committee, as you probably know, being, as I say, associated with James Douglas himself an important and influential member of the committee. But C.J. France seems an entirely unlikely enthusiast for Marbury and Madison and everything that followed. It seems clear from the papers of the Constitution Committee that his involvement in the committee was principally directed towards the question of establishing the ownership by the new state of its natural resources. And we do know that during the progress of the committee, Douglas was warned by other American contacts against C.J. France. Brian Farrell, in his series of articles in the Irish Jurist, records a letter to Douglas which he in turn passed on to Collins, and which stated that we have no knowledge, of course, of what Mr. France's ideas or sentiments regarding the constitutional provisions are. He may reflect our sentiments, and he may correctly reflect predominant American sentiment, but we do not know, and therefore our concern can be readily understood, especially as his brother came out of Russia recently with ideas and opinions regarding the establishment of a government there that shocked and astounded the great majority of thinking Americans. Subsequently, Douglas appears to have been driven to the conclusion that on the face value of the correspondence, France looked like, quote, a pure adventurer, close quotes. Now, the ideas that C.J. France's brother had, and which it was suspected he might have, were, of course, socialist and communist ideas. And it seems probable that France did share these ideas, which were dubious, if not shocking, to most of the other Irish Americans who were in correspondence with Douglas and others. This was a period in the US where the IWW, the International Workers of the World, were particularly active, especially in the northwest of western states of the United States. Eugene Victor Debs, a socialist candidate for the president and a member of the IWW, won nearly 1 million votes in the presidential election in 1920. And one interesting indicator of the view of France can be found, I think, in a fascinating speech delivered by Hugh Kennedy later to the semi-centennial meeting of the American Bar Association in 1928. It is itself entitled Character and Sources of the Constitution of the Irish Free State, and refers to the influences of the written constitutions of the United States, Germany and Switzerland, but nowhere addresses the question of Article 66 of the Free State Constitution, or draws any parallel with the constitutional jurisprudence of the United States Supreme Court. Hugh Kennedy himself is an interesting and complex character. He is my predecessor in the sense, being the first holder of the office I now hold. And I know that Thomas More, for example, has done very valuable work on the Kennedy Papers and on his involvement in affairs in the early part in the 1920s and 30s. And I think it would be particularly valuable to have a fully rounded picture of this talented, complex, and I think sometimes difficult man. He undoubtedly could be both passionate and eloquent. And that speech to the American Bar concludes with a ringing passage. He says, "To adapt the poet's modest claim, it may be a poor thing, but it is all our own, and as such we assert its authority and claim upon our people. This boast at least we may make without fear of challenge, that under the institutions as we have made them, there is no room for ascendancy of class or religion, and the upgrowing youth of our state will compete with equality of opportunity in a free country to whose service they are now called to give of their best, in conditions which realize what seemed the wildest dreams of their fathers, conditions which end a feud of centuries and open up the economic and other possibilities which should flow from the reconcilement of historic enmity." Now, during the speech, Kennedy gave quite a detailed account of the drafting of the Constitution and described, although he did not identify by name, all the members of the committee, drawing attention, for example, to the US connections of James Murnaghan, or James Murnaghan's father, in fact. But he made no reference to the one US lawyer who had been a member of the committee and who had indeed cooperated closely with Kennedy and signed Kennedy's draft B, which is attributed to Kennedy. And this is all the more striking because the conference was being held in Seattle, France's hometown, and it seems apparent that Kennedy was warned, or perhaps had already come to the conclusion, that reference to C.J. France in the US would not be welcome among US lawyers. The picture of France which we can glimpse, therefore, is one which makes him a very unlikely enthusiast for judicial review. After all, in the United States, Lochner and the US was only 17 years old. Plessy and Ferguson had been decided some 24 years earlier, and Dred Scott was still vividly remembered. It is very unlikely, therefore, that somebody who would have found themselves on the left of the spectrum in the US would have considered that giving the power of judicial review to courts would be a good idea. And all of this is more interesting and perhaps striking because, as we know, Draft C, which was produced by Alfred O'Reilly and also signed by someone of the significance of James Murnaghan, only contemplated the possibility of review of the validity of acts of the executive and specifically excluded that possibility in the case of legislation. And that was reputedly because O'Reilly considered that the influence of the US Supreme Court explicitly in cases such as Lochner had been unhelpful in the manner in which it was understood to have constrained legislation introduced by progressive legislatures. Unfortunately, perhaps because Draft C only became available late in the day, there does not appear to be much extensive debate about this issue which interests us so much, and so the thinking behind the provisions of Article 66 remains something of a mystery. But it may be that we have been looking at this wrongly through modern eyes, and starting from the proposition that since judicial review was an anathema to the common law system under the Westminster model, at least in the United Kingdom, that then we should look for some decisive reaction to this by reference to the US. And it may be that the story is more nuanced. I've previously discussed the impact of the debates over the three Home Rule Bills, and in particular the Home Rule Bill of 1893. And I also had occasion to consider this history in the context of preparing for Maguire and Órla. The reason why it was necessary to consider the history was that one of the issues to be decided in that case was whether the power to conduct the inquiry at issue was one that could be said to be inherent in legislatures and not require explicit conferral by the Constitution. That in turn involved looking back to the 1922 Constitution, because the essential provisions in relation to the powers of the Oireachtas were the same, and in turn involved looking at the Privy Council case of Kiley and Carson back in 1842, which had decided that unlike the Imperial Parliament, colonial legislatures had no inherent power to punish for contempt, and had, by extension, we argued, only those powers expressly conferred by the legislation of the Imperial Parliament establishing the subordinate legislature. It may be, I think, therefore, a mistake to think of judicial review per se as an anathema to the common law, or indeed even to the British Empire or the Imperial Parliament. In fact, judicial review of subordinate legislatures was commonplace in that context. Any of the provisions of self-government of the dominions or colonies required legislation establishing the division of functions and powers between the Imperial Parliament and the newly established colonial or dominion legislatures. And furthermore, that division must be capable of enforcement by courts. As the recent case in the United Kingdom Supreme Court on Scottish devolution or a Scottish referendum has shown, this is in itself important constitutional law to be determined by courts. And the Government of Ireland Act 1920, which for a long time was in effect the Constitution of Northern Ireland, is a very good example. Section 4 of that Act contains a significant number of restrictions on the power of the legislatures to be established under the Act, and a provision that any legislation enacted by the legislature of Northern Ireland or Southern Ireland, as it was then described, would, in breach of those provisions, would be void. And that section is followed then by Section 5, which set out explicit guarantees of religious freedom, prohibitions on religious discrimination, guarantee of freedom of religious education, and a prohibition on confiscation without compensation. Looked at in this way, what was unusual about the Irish Free State Constitution was not that the validity of the acts of the newly established legislature could be reviewed by the courts, but rather because the Constitution, by reference to which those acts could be reviewed, contained a particularly expansive statement of fundamental rights, going well beyond the template of the Government of Ireland Act 1920. The fact that the Irish Free State Constitution contains at its very outset the expansive statement of fundamental rights most of which made their way into the 1937 Constitution almost unchanged, was perhaps one element of good luck in what was otherwise an unhappy story. The history of the Home Rule Bills and the Government of Ireland Act suggests strongly, I think, that the British side may have wanted to protect the minority in the new state, and the Irish side wished perhaps to emphasise the independence of the state, its difference from the prior legal order, and its essential equality with the newly emerging states in Europe, for example. If so, and if this led to the provisions, to the identification and enumeration of fundamental rights and the provisions of Article 66 of the Constitution, providing explicitly that the validity of laws could be subject to the jurisdiction of the courts, then that is certainly something to be grateful for. And it makes it perhaps appropriate that I should be addressing you, as it were, from this distance, because the Statement of Fundamental Rights owes perhaps as much, if not more, to our European friends, as indeed we discussed in Karlsruhe last week, as to the admirable example of the US Federal Constitution. All of this illustrates, I think, the fact that we still lack some knowledge as to the influences that led to the adoption of the 1922 Constitution, but also that that text remains overall a matter of real current relevance, and perhaps most importantly, that there remains work to be done. And so I congratulate everyone at this conference for doing it. Thank you.
Thank you. Our next speaker is a Supreme Court Judge, Mr. Justice Gerard Hogan, who's obviously also been a judge on the High Court and the Court of Appeal. He spent time as an Advocate General at the European Court of Justice and has been a lecturer at Trinity College Dublin. He's regarded, I'm sure most of you know, as one of the foremost constitutional lawyers in Ireland, and he'll reflect on how and what the 1937 drafters learned from the Free State Constitution and the fundamental error they made in 1922.
Okay, Órla. I've, I think, 15 minutes, and this present lecture should be seen as, or at least I regard it as the third that I have just delivered on the general topic of 1922 in the last few weeks. The first two, one was in Clonakilty and the other was last week in UCD. And in those lectures, I argued that the Civil War should best be seen as an attempt by a small but well-armed minority to usurp the authority of the Dáil, and the results of the election for the third Dáil on the 16th of June 1922. And I made the point that I can't help but thinking that the fundamentally anti-democratic character of the revolt by the anti-treaty side is insufficiently emphasised even today by those who comment on the Civil War. It was, in essence, I contend, an attempt at an army coup d'etat. Now, I can well understand the concerns of those who oppose the treaty, but it didn't entitle them to resort to violence when they lost that Dáil vote in January 1922. The second Dáil, let us recall, was, after all, an all-Ireland body, and there was no oath of allegiance required. Now, I then explored in those lectures why the Civil War was not seen as an attempt by disaffected elements of the army to repudiate the civil authority and the civil power, even though that's essentially what I think occurred. And one of the reasons I put forward was because the nature of the conflict between the majority in the Dáil and the elements of the army was obscured by the confused constitutional arrangements which existed in the nascent Irish Republic of 1919 to 1922, specifically the absence of an effective judicial review mechanism and a lack of clarity as to what the Grundnormen were in Ireland in 1922. Now, of course, the Constitution of 22 only partially addressed these concerns, and it would take the Constitution of 1937 before these democratic Grundnormen were fully bedded down. But nonetheless, I contended in those lectures that the wanton breach of the fundamental principle of democracy constituted a grave form of original sin on the part of the anti-treaty forces. And fortunately, the commitment to democratic rule and the subjugation of the army to the civil power was subsequently made crystal clear by both the Constitution in 1922 and by the Constitution in 1937. And echoing provisions from 1922, Article 15(6) says of the Constitution reserves the right of raising military military or armed forces to the Oireachtas, and Article 28(3)(1 reserves the right to declare war to the Dáil. Now, in this lecture, I seek to, in a sense, to go beyond 1922 in order to explore what was a fine and immensely praiseworthy document. It represented the first written constitution against the British common law tradition of an unwritten one. It provided for, as we've all know and we've heard today and just heard from the Chief Justice, for the most un-British features of popular sovereignty, the procedure for initiative and referendum, and a catalogue of fundamental rights provisions. And as Donal Coffey and others have shown, the drafters looked especially at continental constitutions, particularly the Weimar Constitution of 1919. Now, you might think it remarkable that a person, namely Mr. De Valera, who was prepared to encourage and supported those who resorted to arms against the Dáil in 1922, would later come to admire that very document of 1922. Yet he did. It was just like many things that he did after 1922. He could not admit this publicly. Proof of this was that every member of the key drafting team in 1936-37, John Hearn, Michael McDunphy and others, had been a pro-treaty supporter. And further proof comes from the fact that so many of the individual provisions in 1937 replicate the language, sometimes with simply verbal changes, of 1922. But much as I admire the Constitution of 1922, and it was a fantastic achievement given the time frame and the lack of experience of the drafters, I think nevertheless, on the whole, the 1937 Constitution is a better, and in some respects, an even far better document, subject to certain qualifications which I'll mention in a moment. And certainly there was much that was new and novel in 1937, which is to be admired. Enhanced judicial review, an extended catalogue of fundamental rights, provisions for international law, the presidency, and so forth. The major qualification, of course, and this is in a sense echoed by the somber piece of Aoife O'Donoghue earlier this afternoon, which would make us all pause to think. But the qualification is that the 1937 document reflected more faithfully the Irish nationalist Catholic zeitgeist in a way that wasn't true of 22. Now, in the last 20 years or so, 50 years or so, that zeitgeist has begun to change, often dramatically. And the existence of these provisions that were characteristic of 37, such as the original prohibition on divorce, the recognition of the special position of the Catholic Church as guardian of the faith of the majority, not special position in itself, of course, but simply in that capacity, tended to obscure the real achievements of 1937, which in turn achievements had been built on in 1922. It is only as the process of secularization, which commenced in or about this day in 1972 with the referendum on the deletion, the Fifth Amendment of the Constitution, with the deletion of the Special Position Clause, and which has now perhaps almost run to completion, not quite, that the real merits of 1937 are there for all to see. We now have a document which at every turn reinforces democracy, the rule of law, fundamental rights, effective judicial protection, and the ultimate ground norm of popular sovereignty. And there's here much to admire. But to return for a few minutes to 1922, that document was, as the Chief Justice has just indicated, saddled with two major handicaps. First, it was inextricably bound up with the treaty, although that was an unavoidable feature of the political agreement of December 1921. And the second was a last-minute change to Article 50 of the Free State Constitution during the Dáil debates in October 1922, which provided that amendments could be made other than by way of referendum for the initial 8-year period. And we all know how this ultimately led to the undoing of the Constitution, because with the Constitution Amendment number 17 in 1920, that period was extended from 8 years for another 8 years. So during the entire history of the 1922 Constitution, it could be amended by ordinary legislation, and that, of course, was seized on in many ways by the courts in order to undo it. And as in the very last judgment of the old Irish Court of Appeal, Sir Charles O'Connor, Master of the Rolls in a case called Regina Cooney and Clinton, said in May 1924, it's difficult to see how the period of 8 years, any act passed by the Oireachtas can be impeached as ultra vires, quote, for so long as it was in the terms of the scheduled treaty. And so, therefore, you had this implicit amendment doctrine, which existed right throughout that period. In the full paper, I draw attention to the fact that the Weimar Constitution suffered from exactly the same flaw, this idea of implicit amendment. Nobody knew exactly what the Constitution provided. And very interestingly, the same solution was provided both in 1937 and indeed in 1949 for the German Basic Law, because the very elegant solution of Article 46 and 43 and Article 46(4) of the Constitution, saying that the bill had to expressly say it was to amend the Constitution, and furthermore, a bill containing a proposal for the amendment of the Constitution shall not contain any other proposal. And you have to wonder, indeed, whether the language of Article 79(1) of the German Basic Law of 1949, which is in many respects so similar, wasn't in part at least inspired by the Irish example, because it says, in order to prevent this very thing which caused the destruction of Weimar with even more and far more catastrophic consequences, as we know, for that society and for the rest of the world, the Article 79(1) now says that the Basic Law can only be changed by a law that expressly changes or supplements the wording of the Basic Law. Now, what's in the remaining 5 or 6 minutes, I just want to say this. What's just as interesting is why the drafters of the Constitution in 1937 not only continued with the experiment of judicial review of legislation, but actually took the opportunity to strengthen and copper fasten these powers. We know that planning for the new Constitution began in earnest in 1934. And the period between 1932 and 1936 was, of course, notable for the fact that there was the ongoing, if you like, the latest phase in the duel between the Irish government, previously Cumann na Gael, but then post-March 32, Fianna Fáil with the Privy Council. And then, very fortunately, in one way for Mr. De Valera, first you had the Statute of Westminster in December 1931, and then, perhaps even more importantly, Moore and the Attorney General in June 1935, the Privy Council held that the Statute of Westminster essentially gave the Oireachtas the power to dismantle the treaty. Now, rather remarkably, the Supreme Court had come to the opposite conclusion in the state Ryan and Lennon in December 1934, reasoning, the majority said, that as the Dáil, and indeed probably Kennedy as well, a Constituent Assembly had never been given the power to amend the treaty to the new Oireachtas. So there was the potential there for a fundamental clash on the most fundamental of questions between the Supreme Court and the Privy Council, and that in itself was one of the reasons why there had to be a new constitution. Now, I do, in the rest of the paper, chart some of the history, and in particular, I think a very important committee is the Constitution Review Committee of 1934, which involved Hearn, Stephen Roach of the Department of Justice, and others. And they would be, with the exception of Roach, key part of the drafting of the new constitution in 36-37, and that really shows in a way how ultimately by 1934-35 the merits of 1922 were fully recognized, but experience had shown that certain things would have to change. Therefore, it's interesting just to focus on one or two things where there were improvements and where things might, with advantage, have been changed. So, just to pause on, take one thing, Article 50 of the 22 Constitution had actually provided that if you were going to have a referendum, there was never a referendum in the history of the Free State as such, apart from the plebiscite in the new Constitution on the 2nd of July 1937. But Article 50 had made the passage of the referendum depend on either the electoral turnout or an artificially high majority. So you had to have either a majority of the registered voters, or failing that, 2/3 of the or a 66.66% majority. And that, I think, was unworkable and was unwisely dropped in 1937 so far as ordinary constitutional amendments were concerned. But a version of it was retained for what are misleadingly described in the Constitution as ordinary constitutional amendments. That is to say, Article 27 bills which have been put to the people following a majority of the Seanad and 1/3 of the Dáil petitioning the President to do this. It's never happened, and one of the reasons it would never happen is because the result is really unworkable. It's either depends on the electoral turnout, this idea of it passes unless there is a particular percentage of the population on the register have negatived it. In conclusion, some other random examples can be mentioned briefly in the 2 or 3 minutes I have. 38.3, dealing with the Special Criminal Court, is, I think, a big improvement on Article 2A. And De Valera, I think, correctly challenged John A. Costello in the Dáil debates on the draft of the Constitution as to whether he would be happy with describing, as Article 6 of the 22 Constitution did, personal liberty as, quote, inviolable. Not surprisingly, Costello admitted that he wasn't. And the new Article 40.4.1 protects personal liberty in an important fashion without resorting to that elevated phrase, inviolable. And then just to return to my earlier 2 lectures, I said in both of them, and I'm going to say again, that in the closing lines of Gore Vidal's great historical novel, Lincoln, the author attributes to John Hay, Lincoln's loyal young secretary, the view that Lincoln, in some mysterious fashion, had willed his own murder as a form of atonement for the great and terrible thing that he had done through the Civil War. And in much the same vein, I have come to the conclusion that by giving us an elegantly drafted constitution, which above all else reinforced democracy and the rule of law at every level in our political system, and which provided for the will of the people as its ultimate grundnorm in a way that, as a society, we still do not properly value or appreciate, De Valera sought thereby to atone for his mendacity, narcissism and petulance by defying the will of Dáil Éireann in the course of 1922, and for failing to acknowledge at the time the merits of the 1922 Constitution. It was those failings which had fanned the flames of an unnecessary and destructive civil war. Yet, ladies and gentlemen, in conclusion, on this day, and in this place, let us adopt the spirit of forgiveness and generosity, which is one of Lincoln's defining characteristics, by acknowledging that by way of implicit atonement for 1922, De Valera opted decisively for democracy and the rule of law in 1937, and cemented it firmly in the fabric of society, in a way which the drafters in 1922 had sought to do, but had not fully been able to achieve. Democracy is a fragile plant, and let us both be grateful that in both 1927 and 37, there were people who were prepared to provide the warm earth and the adequate moisture which would enable it to grow and flourish. Ladies and gentlemen, thank you very much.
Thank you very much, Judge Hogan, and I'm a little bit disappointed because I thought today was going to be the day when I'd be able to tell the judges they'd gone over their time, they needed to be quiet, but he has surprised me by being shorter than anticipated. So our final speaker tonight is newly appointed Supreme Court Judge, Mr. Justice Maurice Collins. As a senior counsel, he was centrally involved in many of those major constitutional cases that I found so fascinating over the years, and of particular relevance to today's events. Like many others in this room, he has a personal connection to the events of 1922 in the fact that he's also a grandnephew of Michael Collins. He will reflect on how the new courts established by the 1922 Constitution dealt with that document, how they discussed it. So, Judge Maurice Collins.
Thanks, Órla. I'm not certain if the theory of implicit atonement has any more robust basis than the theory of implicit amendment of the Constitution, but perhaps that's to speak outside my area just at the moment. Thank you to Laura and to Donal. Laura expressed surprise when I told her what I proposed to speak about, and I understand that better now than I did then. What I propose to say is something about the way that the courts talked about the Free State Constitution before its abrogation and replacement in 1937. The enactment of the Constitution of the Irish Free State Saoirse Éireann Act on the 6th of December involved, or at least appeared to involve, a radical rupturing of the established legal order in the state, and much has been said about that earlier. The new Constitution gave new rights and freedoms, including the right to liberty, freedom of conscience, expression, assembly, and association, and provided for a new and independent court system to enforce those rights, with the judicial power notably extending to the question of validity of any law having regard to the provisions of the Constitution, in Article 65. Much has been written about the 1922 Constitution, and much will, I suppose, continue to be written in its centenary year. The view of Donal Coffey that it was an experiment which ended in failure is widely held and difficult to dispute. That is not simply the judgment of hindsight. The 1922 Constitution failed in real time and in plain sight. Hugh Kennedy's foreword to Cohen's The Constitution of the Irish Free State should perhaps be read as part early obituary and part pathologist's report, both recording and offering an explanation for the demise of the first legislative and the fundamental instrument of the new state. Part of that explanation, of course, being what was suggested to be the continuing baleful influence on Irish institutions of legal education of Dicey and the proponents of legal positivism. 2 years later, in December 1934, the Supreme Court gave judgment in State Ryan and Lennon, and the unravelling of the new settlement was effectively complete. I'll say something more about State Ryan and Lennon below. I know it's been referred to earlier, but in truth it's an irresistible temptation to talk about it. But I would have to venture to suggest that the judgments of Chief Justice Kennedy and Fitzgibbon, judge, not the only judgments who were given, but the judgments that are perhaps most frequently referred to and remembered, are different in many ways, but may each be seen as something of a howl of rage. It did not, of course, start that way. The Constitution enacted by Dáil Éireann on the 6th of December, qua Constituent Assembly, and not, as the Chief Justice stressed in his judgment in State Ryan and Lennon, qua the Oireachtas, appeared to establish a modern constitutional democracy with significant protection for fundamental rights, though it did not characterise them as such, a point to which both Fitzgibbon and Murnaghan judges attached weight in their judgments in the State Ryan and Lennon. According to Hannah J. in the State O'Duffy and Bennett, the Constitution expressly conferred on the citizens of the state every fundamental constitutional right as known and embodied in the common law against autocratic or military power, adding that no constitutional lawyer could have asked for more protection to the citizens, save that these rights should be permanent and that they should be sufficiently safeguarded. That was, of course, a very significant saver. The Constitution as adopted also contained innovative provisions providing for the referral of legislation to the people by way of referendum under certain circumstances in Article 47, as well as the provisions of Article 48 in relation to popular initiative. These, of course, didn't stick, but Article 47, as we'll see, features in some of the cases, including as an important part of at least one of the strands of analysis of the Chief Justice as to why the apparent amendments of the Constitution that effectively gutted it weren't effective. The Constitution has been characterised aptly, in my view, as austere in its drafting, avoiding the use of rhetorical flourishes, I beg your pardon, that may be found in Bundock na hÉireann. It was also notably secular in tone, with the sole reference to God occurring not in the Constitution itself, but in the recital to the Constitution Act, which was, of course, subsequently the foundation, however fragile, for the natural law argument advanced by Chief Justice Kennedy in the State, Ryan and Lennon. As a matter of Irish constitutional theory, as Gerard has touched on, the 1922 Constitution was a product of Irish law. It was adopted by the Dáil pursuant to its powers as Constituent Assembly. In that, of course, the view differed from the view subsequently taken by the Judicial Committee of the Privy Council in Moore, as Gerard has mentioned. But as a matter of Irish law, the issue was put beyond doubt by the decision of the Supreme Court in the Criminal Law Jurisdiction Bill reference in 1975. That in Article 50, the amendment provision, the 1922 Constitution contained what the Chief Justice referred to aptly as the seeds of its own destruction, is clear. The arc of that destruction that culminated in the State, Ryan and Lennon can be traced back to the decision of the Court of Appeal in Cooney and Clinton, to which Gerard has referred, which, although decided on the 23rd of May 1924, less than a month before the establishment of the new courts under the Courts of Justice Act 1924, was not reported until 1935, when it was reported as a note to the State, Ryan and Clinton and Lennon. But in this paper, I'm not seeking to review how the 1922 Constitution appeared in practice. Rather, I want to say something about the way in which the courts spoke of the Constitution during its lifetime. Does the language used by the courts suggest an enthusiastic embrace of it as the fundamental instrument of the new state, constituting an entirely new legal order? Or did the courts effectively approach the Constitution from a positivistic or conservative perspective? Was the voice of the Gael, to use the expression used in an article by Ronan Keane, liberated from the spectral thraldom referred to by Chief Justice Kennedy in his foreword to Cohen's text? In truth, the position revealed by a review of the decisions in the Irish reports is untidy and difficult to interpret. The data set is small, and Article 50 throws a long shadow over what there is. The reality is that judicial review under the 1922 Constitution was effectively stillborn, and the judicial dialogue about judicial review and about the values that it embodied and required to be applied never really got started. Having said that, there was no lack of recognition of the new constitutional dispensation, at least initially. Remarkably, the first decision and the only decision that I'm aware of in which a court expressed the view, though it may not perhaps have declared or ordered, that a piece of legislation enacted by, or apparently enacted by the Oireachtas was null and void, was another decision of the old Court of Appeal prior to its replacement. The decision of the King O'Brien versus the military governor of the NDU internment camp. It provides an early and striking example of judicial review. In essence, and I'll shorten the summary I have here, in essence, in return to an order of habeas corpus granted by the court, the government came in to say that the prisoner was being detained pursuant to an order made under the Public Safety Act of 1923, the Public Safety Emergency Powers Act of 1923, which the court was told had been enacted the previous day. It was argued that that was bad because the provisions of Article 47 of the Constitution effectively permitted a period of 7 days within which a specified proportion of the legislators in either house could pause the legislation and then seek, by way of further resolution, to have the legislation remitted to the people by way of referendum. The state answered in response that the legislation was duly enacted, and had been signed by the King's representative, the Governor-General, and that the court could not look behind it. That argument was rejected by the Court of Appeal in judgments of notable robustness. According to Lord Justice Ronan, Article 47 was a very important article of the Constitution, the essence and substance of which was the creation of a referendum. A referendum is the most important element in a democratic constitution, and the substance of a referendum is that in certain cases and in certain circumstances, the people themselves are to have a vote, to determine whether a law should be passed or not. That the law shall be finally submitted, in the words of this article, to the decision of the people. The arguments made by the government, in essence, that whether there should be a referendum or not was a matter for the discretion of the President of the Executive Council, made, in the words of Lord Justice Ronan, a farce of the entire thing. The giving of royal assent to a bill within a few hours of its passing the two houses would be an absolute fraud on the Constitution, and accepting the construction of Article 47 contended for by the government would sweep the referendum out of the Constitution. Similarly, Chief Justice Maloney, formerly the Lord Chief Justice of Ireland, and after that the Lord Chief Justice of Southern Ireland, after the coming into operation of the Government of Ireland Act, though he asked the King for permission to continue to style himself the Lord Justice of Ireland, Lord Chief Justice of Ireland, also agreed that the legislation contravened Article 47. It would render it nugatory, in his words. The prisoner was released accordingly. Subsequently, in Attorney General versus McBride, a decision from 1928, the Hannah J. in the High Court suggested that in O'Brien, the court had declared the Public Safety Emergency Powers Act null and void. That may well have been the logical consequence of the court's decision, but the only order expressly referred to in the judgment itself was an order restraining the prisoner. Even so, it is a remarkable decision, not least because the judges who gave it were stalwarts of the pre-1920 legal regime. It appears to be the only instance in which legislation enacted by the Oireachtas under its powers under the 1922 Constitution was successfully judicially reviewed under the Constitution. The forceful and expansive language in O'Brien is notable for its absence from OConnell and the military governor, a decision of the King's Bench Division on another habeas corpus application. And of course, the courts faced a diet of these applications, many of them answered by orders made under various pieces of emergency legislation. This was one of these. The prisoner was in detention on foot of an order made under the Public Safety Powers of Arrest and Detention Temporary Act 1924, and it was argued on behalf of the prisoners that the Act contravened Articles 4, 64, 70 and 72 of the Constitution by effectively permitting detention without criminal trial before a court established under the Constitution. Those arguments were given short shrift by the court, with all of its members emphasising the broad scope of the legislative powers of the Oireachtas. All members of the court took a notably formalistic approach to the prescription in Article 6 that no person should be deprived of his liberty except in accordance with law, and to Article 70's requirement that no one should be tried save in due course of law. That formalistic approach to those provisions was a feature of subsequent jurisprudence also, including notably the majority judgments in State, Ryan and Lennon. Of course, under the 1937 Constitution, after some uncertainty and expressions of different views, it's now well established that reference to in accordance with law and to in due course of law imports something more than simply a law enacted by the Oireachtas. but engages the substantive quality of the legislation. It should be said in this decision, O'Connell, that one of the judges, Pim J, again a pre-new dispensation judge who didn't become a judge, I think, under the Courts of Justice, did allow that a permanent law that gave the executive power to deprive any citizen of his liberty without trial would be contrary to the spirit of Article 6 and therefore a violation of the Constitution. But that was, he said, a very different thing from a temporary law made in abnormal times and for a temporary purpose. That decision was appealed to the Court of Appeal. The Court of Appeal of Ireland, or perhaps more correctly, the Court of Appeal of Southern Ireland, as it still was under the Government of Ireland Act 1920. The appeal was heard and decided along with Cooney and Clinton, which, as I've said, although decided in May of 24, was not reported until 1935. In Cooney and Clinton, the state relied on a section of the Indemnity Act 1923 to justify the continued detention of somebody who had been tried and sent to imprisonment by a military tribunal before the cessation of the Civil War. In turn, the prisoner suggested that Section 3 violated Articles 6, 70 and 72 of the Constitution. Those being those provisions that guaranteed trial and imprisonment only after trial. Nothing in Section 3 or in the 1923 Act purported to amend the Constitution at all. The Master of the Rolls, O'Connor, who had, of course, given the celebrated decision in Egan and Macready, and who had also ruled against the habeas corpus application of Erskine Childers and the Adjutant General, and who was appointed a member of the Supreme Court on its establishment in June 1924, allowed that the argument may raise a grave constitutional question, though he was, quote, far from saying that the Constitution as it stood at the date of the passing of the Indemnity Act that there was not power in the Oireachtas to pass such an act without any amendment of the Constitution. However, it was, in his view, quite unnecessary to consider the question further, having regard to the terms in which the power of amendment conferred by Article 50 of the Constitution was framed. It's difficult, and this is a passage that Gerard has referred to, difficult to see how during the period of 8 years any act passed by the Oireachtas can be impeached as ultra vires so long as it is within the terms of the scheduled treaty. As for the argument that legislation purporting to amend the Constitution should declare that it was so intended, the Master of the Rolls was dismissive. I cannot accede to that argument in view of the express provision that any amendment made within the period may be made by ordinary legislation. The appeal in O'Connell failed on the same basis. The holding in Cooney and Clinton clearly had major implications for the status and effect of the 1922 Constitution, and it appears to have been raised shortly afterwards in the Dáil, only to be dismissed by the President of the Executive Council as the product of a court that had no competence to interpret the Constitution. Whether because it was overlooked or otherwise, the discussion in Orrin Clinton was not referred to, the decision in Orrin Clinton was not referred to in Attorney General in McBride, where Hannah J. came to much the same conclusion about the implicit amendment of the Constitution. It can't be gainsaid that the Constitution could, during the period of 8 years from the date that it was brought into operation on the 6th of December 1922, be amended by ordinary legislation enacted by the Oireachtas, having regard to the terms of Article 50. But the argument that any such amendment had to be presented and adopted expressly as such, as an amendment, unquestionably deserved closer and more anxious consideration than it received from the Master of the Rolls in Cooney and Clinton. The arguments for reading such a restriction into Article 50 were rehearsed by Hannah J. and Attorney General in McBride. McBride concerned yet another piece of emergency legislation, the Public Safety Act of 1927, which had been enacted in the aftermath of the assassination of Kevin O'Higgins. Section 16 of the Act provided for the detention of up to 3 months, initially on the order of a district justice and then on the order of the executive, of persons suspected of being or having been engaged in the commission of a scheduled offence. The prisoner had been arrested on suspicion of conspiring to murder Mr. Reagans, and an application was made in the district court for an order for his detention, which had been refused. The Attorney General had sought certiorari and mandamus. Hannah J's judgment begins with a paean to the right to personal liberty, which we have inherited as the heirs of the ages of the common law, and which had been accentuated and emphasised in the Searstad by its incorporation in this specific article of the Constitution, which also in the terms proclaims that the High Court shall be its guardian. The embodiment of this principle is in the Constitution, while securing it more amply and by making it more difficult to suspend, efface or weaken, accentuates its importance in the Searstad as a fundamental right of every citizen. There was, of course, a but, and it was a significant one. Under Article 50 of the Constitution, amendments could be made by way of ordinary legislation. Section 3 of the 1927 Act provided that every provision of the Act which contravened any provision of the Constitution would, to that extent, operate and have effect as an amendment of such provision for as long as the Act continued in force, a period of 5 years. Thus, the question was, as it was put by Hannah J., is it a sufficient compliance in law with Article 50 to insert in an Act of Parliament in vague and general terms a clause such as this, a dragnet, without specifying either any article or part of an article of the Constitution that is to be amended, or whether in fact any amendment is made? Hannah then set out what might be thought to be a compelling argument that such an approach would not comply with Article 50. The Constitution is a sacred charter, not to be lightly, vaguely, or equivocally tampered with. But this Section 3 leaves the subjects of the state who have rights under the Constitution and rights to exercise against amendments of the Constitution in the dark as to what it really altered in the Constitution, instead of enlightening them as to any change in their status. An omnibus amendment of this kind is contrary to the spirit of Article 40, if not to the letter. The rights of the people should not be obscured by the facile pen of the parliamentary draftsman. However, while noting that the matter had not been fully argued before him, the judge nonetheless concluded, having regard to the wording of Article 50, that the amendment can be made by way of ordinary legislation. I feel compelled, but with great hesitation, to come to the conclusion that this Section 3 comes within that term, but it is a precedent that should not be followed. Again, one may legitimately question the adequacy of this analysis and the persuasiveness of the conclusion reached. If indeed the Constitution was a sacred charter not to be lightly, vaguely, or equivocally tampered with, was there not therefore a compelling argument to be made that the Oireachtas, when exercising its power to amend the Constitution under Article 50, should at a minimum be required to legislate in express and precise terms so that the provisions of the Constitution could at all times be clearly identified? To impose such a requirement would not prevent the amendment of the Constitution, but would at least have prevented its amendment by a side wind. It need hardly be said that the admonitory injunction at the end of Hannah J's judgment that the precedent of the 1927 Act was one that should not be followed proved entirely impotent. The same drafting technique was the subject of adverse comment by the judges in the State Ryan and Lennon. I'm going to skip over some of the intermediate decisions, and before coming to the State Ryan and Lennon, which I will in a moment, there is the important decision of the Supreme Court in Lynham and Butler concerning the separation of powers under Article 2 and the extent of the judicial power under Article 64 in the context of the functions of the Land Commission under the Land Commissions Act 1923. Kennedy, Chief Justice, was anxious to make it clear in his judgment that no argument had been made to the effect that the Land Commission Act of 1923 had effected any amendment of the Constitution by implicit means. Such a contention, he went on, if it ever should come to be advanced for discussion, will raise considerations of profound importance as between the fundamental law of the state enacted by the Constituent Assembly and the method of amendment thereof by the Legislative Assembly during the period during which amendments may be made by the process of ordinary legislation. Even so, in his judgment, Fitzgibbon J suggested that even on the assumption that the impugned provisions of the 1923 Act were repugnant to the Constitution, as infringing Article 64, the exclusive judicial power to administer justice, it was at least arguable, he said, that they were valid as amendments under Article 50, adding that, "I'm not prepared to accept without further argument the view that the Constitution cannot be amended unless the statute containing the amendment is expressly described as an act to amend Article X of the Constitution. And in my opinion, it may well be that upon the principle leges posteriores priores abrogant, the later legislation abrogates the former, any enactment of the Constitution clearly inconsistent with the Constitution passed within the period during which amendment of the Constitution by ordinary legislation is permitted should be construed as an amendment that pro tanto, especially where, as in the present case, there's a direct reference to the material provisions of the Constitution." With that preliminary skirmish out of the way, which of course set the scene for the more direct confrontation in the state Ryan and Lennon, the Supreme Court addressed the substantive issue. 3 judgments were delivered. The court at that stage consisted of only 3 judges. It wasn't expanded to 5 until 1936. The judgment given by the Chief Justice, which has been cited many times since, including extensive citation in the important Supreme Court decision in Zalewski, certainly has its fair share of elevated rhetoric. The judicial power, he observed, was one of the attributes of sovereignty and one of the activities of the government of a civilized state by which it fulfills its purpose of social order and peace by determining in accordance with the laws of the state all controversies of a justiciable nature arising within the territory of the state, and for that purpose exercising the authority of the state over person and property. The exercise of the judicial power of this state has been entrusted by the Constitution exclusively to the judges of the state, the manner of whose appointment is prescribed by the Constitution, which also declares their independence. The third Judge Johnson, notably observed that Article 64 will undoubtedly be very useful in the future as a check on encroachment by the legislature and the executive upon popular rights. What future Judge Johnson may have had in mind is unclear, but there's an unmistakable element of whistling past the graveyard in Lynham and Butler, which was brutally exposed in the state Ryan and Lennon. Such was, quote, "the devastating effect of Article 50, close quote, as Meredith J. observed in his judgment in the High Court in that case, that the entire position of the judiciary, even their jurisdiction under Article 65, their entrenched jurisdiction to review the validity of laws, might be changed." 6 judges gave judgment in the state Ryan and Lennon, 3 in the High Court and the Divisional Court, and 3 in the Supreme Court. All but the Chief Justice firmly rejected the challenge to the validity of Article 2A. Of the 5 judgments that went the other way, that given by Fitzgibbon J undoubtedly exercises the greatest fascination. It's tempting, though inaccurate and unfair, perhaps, to view the judgments of the Chief Justice and Fitzgibbon J as reflecting a form of Manichaean struggle for the future of the Constitution. But as I've said, it appears to me that each can be seen as a howl of rage. The Chief Justice raging at the destruction of the Constitution that he had helped to bring to creation, first as a member of the drafting committee, then as Attorney General, and which as Chief Justice he had sworn to uphold. That destruction, of course, flowing from, it might be said, drafting errors in Article 50 that had not been identified by the members of the committee, including the then Chief Justice. And Fitzgibbon J, it appears, raging at everything that had occurred in the Free State since its establishment, raging indeed at the state itself. The conclusion of his judgment in the state Ryan and Lennon is the most bitterly vituperative prose that I think I've ever read. It jolts every time. Looked at across the decades, it has the look of an act of psychic self-immolation. And I think stating Ryan and Lennon, of course, is something that we're all familiar with. But there are just two aspects of the actual prose, seeing as this is supposedly a talk about the language in which the court spoke about the Constitution, that I'm going to read to you. The judgment is a learned one. It refers extensively to other constitutions. It refers specifically to the Constitution of the United States. And I'll just read this part. It's possible that our Constitutional Assembly may have followed too slavishly the constitutional models of other nationalities, and that just as the constitutional safeguards of freedom of speech, trial by jury, security of person and property with others were only introduced into the Constitution of the United States by way of amendment the year after the original Constitution had been adopted, the Bill of Rights, so the amendments of our Constitution, which have been enacted during recent years, whereby these and similar safeguards have been minimised or abrogated, more truly represent our national ideals. If this be so, we find the Britain's conceptions of liberty and justice set forth in his Magna Charta and his Bill of Rights, those of the American in his Declaration of Independence and his Constitution, while those of the Gael are enshrined in Amendment number 17, which is to prevail in case of inconsistency over everything in the Constitution, except Articles 1 and 2. Amendment number 17, of course, was the amendment that introduced Article 2A into the Constitution and effectively set up a parallel system for the administration of criminal justice up to the point of the administration of the death penalty. And after some additional prose to the same effect, and addressing a suggestion that the citizens of the Seerstad might have been misled by the terms of the 1922 Constitution into thinking that they were going to be living in a constitutional democracy with entrenched and protected rights, and that was effectively a false pretense, he says. Fortunately, it can never again be suggested that the Seerstad has obtained citizens by false pretenses. Now that the Oireachtas has promulgated Urbi et Orbi to the Czechoslovak and the Mexican, to our kinsmen in the United States of America and throughout the British Commonwealth of Nations, and above all to our fellow countrymen in Northern Ireland, whose cooperation we profess to desire, as well as to all those we seek or acquire or have thrust upon them rights under our new Irish Nationality and Citizenship Act. Amendment number 17 as an integral part of our Constitution, setting forth in the clearest language, in the forefront of that document, the conditions under which liberty is enjoyed and justice may be administered in, and this is a quotation internally, this other Eden, demi-paradise, this precious stone set in the silver sea, this blessed plot, this earth, this realm, this Seerstad. There's much to admire in the judgment of the Chief Justice. Ultimately, for all its force and conviction and sincerity, it does not, in my view, persuade on the main issue. The central cleavage in State Ryan and Lennon can be and has been seen as a conflict between Austinian positivism on the one hand and natural law on the other. That appears to me to be overly simplistic. There are, of course, different views on that point, and the debate continues. But Kennedy CJ was surely right to insist that whatever its flaws, the 1922 Constitution should not have been seen as another statute, as just another statute. Unlike the 1937 Constitution, it was not directly approved by the people. That clearly would not have been practical in the midst of the Civil War in December 1922. It was, however, solemnly enacted by the Dáil sitting as a constituent assembly. While it was for an extended period capable of amendment by ordinary legislation. That was because Article 50 specifically so provided, subject to the possibility of a referendum being called under Article 47. It would not have been in any way inconsistent with the Oireachtas's power of amendment in Article 50 for the courts to have held that amendments to the Constitution required to be expressly framed and enacted as such, and had to specify precisely the manner in which the Constitution was proposed to be amended. That is now expressly provided for in Article 46 of the 1937 Constitution. But even in the absence of such an express provision, such a requirement might readily have been derived from the nature of the 1922 Constitution itself. That certainly was the view subsequently taken by Mr. Justice Barrington in the Supreme Court in Laurento. The Court's refusal to take such an approach is certainly questionable and can plausibly be attributed, at least in part, to the legal positivist heritage of the judges concerned and their ingrained assumptions about parliamentary sovereignty and perhaps more generally a strain of legal conservatism. There surely was no scope for the application of the doctrine of implied repeal invoked in terms by Fitzgibbon Jay in Lynham and Butler to a written constitution intended to protect fundamental rights. The state, Ryan and Lennon, was not the last time that the 1922 Constitution came before the court, but it's where I propose to stop. It embodies within it the very different ways that the court spoke of the 1922 Constitution and the disastrous effect of Article 50 on the constitutional conversation that might have been expected to follow and develop the enactment of the Constitution 100 years ago. Thank you very much.
Thank you very much, Mr. Justice Collins. It has been a long and very interesting day today, so I propose we'll bring this session to a close. The Chief Justice mentioned that the 1922 Constitution was a glimpse into a different Ireland, and I think Laura and Donal have provided more than a glimpse here today, from the creative spirit of the 1922 Constitution to its fundamental flaws. I'd like to thank Mr. Justice Maurice Collins and Mr. Justice Gerard Hogan for their contributions, and I'd like to invite Dr. Coffey to make the closing remarks. Thank you very much.
It just remains for me to close out proceedings today, and I'm going to do that mainly by means of a series of thank yous to people who were involved in the conference. First of all, I'd like to thank our sponsors, the University of Limerick, the Court Service, Maynooth University Social Sciences Institute, and the Shelburne. The Shelburne have done an amazing job today, and I'd like to particularly single out Kelly McAuliffe for the work that she's done behind the scenes in getting everything ready for today. I'd also like to thank the musicians that you heard on the way in today from the Irish World Academy at UL, George and Ella, for the work that they did in the beginning of the day and during the intervals. Thank you also to Lisa Maybury and the Judicial Assistants, and to Amy Alley and Saoirse for the work that they did, helping with registration and with getting people sorted. And thanks also to Cormac and Ray, our technical impresarios at the back of the room, who've kept things ticking over so faithfully. I'd also like to say thank you to the speakers, the chairs and the attendees who came here today. It's no exaggeration to say that with every talk that I heard today, I learned something new that I didn't know before. And oftentimes it was to look at something that I thought I knew in a slightly different way. And sometimes that's actually the most valuable thing that can happen, is to shed new light on something that you think that you've seen and considered from all different angles. And I think also just like to thank you for giving of your time, because that really is the most precious asset that we have. So to thank you all, everybody who came here today and interacted and was involved with it. Finally, I'd like to thank my co-conspirator, Laura Callahan, for whom the lion's share of the credit for today's success must go. I'm down as a co-organizer. That's very much a minor key. To give you an example of the level of activity Laura was involved in behind the scenes, we had a Zoom conversation at one point in time, and she said, I'm thinking maybe we should do something like a new piece of music, maybe get people to play up here, or maybe we'll do a video. And I said, yeah, sounds good. You want to be, if you did the video, I think you might be able to, maybe you might be able to get the video from British Pate and just put it over that. That was the last I heard of it. And then about 4 weeks later, I got an email with, with a video attachment from Laura, which meant in the meantime, she had composed, professionally recorded, got the rights from British Pate, spliced in the video over the recording, added words to it, and this was the final product that I. Now, I should hasten to point out that I did say that some of the pictures were a bit too pixelated. So if you looked at it and said that pixelation is just right, then okay, I am. But if there was any other element of that video, the credit goes entirely to Laura, and that's true in general in relation to the conference as a whole. For those of you who are interested in further developing the analytical ideas that we've been talking about today, the videos are being recorded, they'll be made available if you want to go back over anything. It's our intention to bring together an edited collection of papers from the volume. We're in discussion with a publisher about it at the moment. For those of you who have presented and have expressed an interest in contributing to that, we'll be in touch with you in the coming weeks, just in relation to details in relation to it. I realize a lot of you have got to get back home and have other responsibilities that you have to take care of. For those of you who are maybe interested in continuing the conversation, I think we'll probably go down to Doheny and Nesbitt's after this for a drink. So if you fancy coming down and joining us, by all means, you're invited to do so. We don't have a booking though, so we're just showing up basically. Besides that, thank you very much.